Thank you very much, CJ. Good evening, Judge.
Good evening, sir.
What is your understanding of judicial overreach? And do you have an examples you can give us on judicial overreach?
Yes, my understanding of judicial overreach is when the courts intervene in matters that are in the terrain of the executive. I don't believe that the Constitutional Court may have been criticized from time to time for intervening in issues pertaining to Parliament. The EFF matter, EFF UDM versus the Speaker of Parliament is one of the matters. There was dissension in the court itself I think the Chief Justice said that this is a classic case of overreach. My view was quite different. I believed that there were certain obligations that Parliament had to carry out under the Constitution, which it hadn't done so, and on that basis, the court intervened, and the court then made an order, obliging Parliament to do what it had to do. In this case, it was to put in place rules, impeachment rules. So I believe that, and I dealt with this somewhat when I answered Minister Lamola's question. Where there's a fundamental right that is violated or infringed, courts are duty-bound to intervene. We are duty-bound to intervene. Where there's a constitutional right, even if it's outside of the Bill of Rights, that deals with functions and powers of other branches of government, and any conduct that is inconsistent with that, or policy that is inconsistent with that and the Bill of Rights, we are required to intervene. We are mandated in those cases to intervene.
Can the Constitutional Court, sitting on the bench there, take away a fundamental right of an individual, like in the Bill of Rights, where the court says to a person, your right to remain silent is taken away? Can the court do that?
No, it can't.
And if the Constitutional Court does that, what recourse do you have?
Well, I think the Constitutional Court is the last court. I don't believe the Constitutional Court will do that. It will never take away a right. And it hasn't done that so far, from my understanding of the jurisprudence that's emerged from that court.
This is just a comment, Chief Justice, because I'm going to raise this point when we meet.
I was hoping you were not going to go there, Honorable Malema.
There's a comment because I'm going to raise it, and I don't want to be accused of being unfair to you. And you'll comment if you want to. I'm going to argue that you are condescending and you treat juniors as kids, and you don't take into consideration that the courts themselves, just the building and the benches, are designed to intimidate. And when you come in a manner you are coming, and the manner you are saying you are coming to people, you are actually worsening their intimidation, and as a result, they are unable to express themselves, and they end up misrepresenting some of the councils, their own clients, because of what you call firmness, which at times comes as if it's a rudeness, and you call people youth, adults who have gone to school, who have graduated to come and work with you. And I think you call them youth because you are here. I get a suspicion that you at times get tempted to refer to them as kids, and you treat them like kids. You're puppeting them. And if that is the approach, you can be guaranteed the youth I lead, you're going to fight with them many times. This is a new youth. We're not the old youth that has accepted condescending attitudes.
I'm sorry, Mr. Malema, when I speak of the youth, I'm not talking about children. Youth can be up to 35 years old. You know that you can be part of the youth league if you up to 35 years old. I am not condescending to my juniors. I really am not condescending. That hasn't been my attitude. If anything, I encourage youth. I encourage the young people that work with me, the young adults that work with me. That has been my experience always, I really am not rude. I certainly am not rude. Firmness cannot be mistaken for rudeness, Mr. Malema. All judges are firm. We are required to do a job, and we have to do it efficiently. And at times may come across as being robust, but we have a duty to the litigants to ensure that they are properly represented. And I said, in 99% of the cases, the litigants are properly represented and counsel's performance is immaculate. There may be a small percentage. I have had counsel who were unprepared before me, who have come back fully prepared. And we have a great relationship. I am not condescending to young people. In fact, I'm very popular amongst young people. And if you know me and you know my relationship with counsel at the bar, and you know my relationship with the young clerks at the court, you will know that I am not condescending to young people. I show compassion. I help build them. I empower them to the extent that I can. I have a number of mentees that were clerks of the Constitutional Court, that were clerks of other judges, that still have a relationship with me and will call me. Mentees that run organizations today, mentees that went on to work at the Supreme Court of Appeal, mentees that are currently doing pupillage at the bar and call me from time to time for advice. So I am not condescending to young people. I have extremely good relationship to young people. There may be a small percentage of the bar that felt that I responded differently to them, but there was no malice in that. I'm sorry, I will not accept that I'm condescending to young people. And I will not accept by referring to young people as the youth, that I'm referring to them as kids. The youth are in fact young adults.
Yes. Thank you, Judge. Is there a follow-up question?
No, Chief Justice. It's not a question at all. I'm just, I'm assuming that there's no next question. I was just reminding you.
No, there is. There is a next question.
Okay, but in any event.
Honorable Malema is on the list.
Okay, but in any event, I'm reminding you, Chief Justice, of the issue.
Oh, thank you. Thank you, sir. Honorable Malema.
Thanks, CJ. Judge, I thought they will ask you this question because it's going to be raised, and it was raised in the last interview. The issue of age, because it looks like you're only going to serve half of what is expected of a judge in the Constitutional Court, and they will be forced to come back here. So I thought you need to help us so that when we go into our deliberations and this matter arises, we've got your view on that matter.
Thank you. Thank you, Commissioner Malema. I'm mindful that if I am appointed, I'll probably serve approximately 6 years. That'll take me to age 70. And so the proposition that arises is that will this be a value for money appointment in respect of state resources and in respect of, and I think it would, because I think it would be unfair to look at the remaining 6 years only. I think one must look at my public record from the time of the early 90s when I served in state institutions. I started working in the Human Rights Commission from 1997. I worked there for 13 years, serving the public, not pursuing a career in private practice, and now 11 years as a judge. In addition to that, I chair the South African Law Reform Commission, which I do in my capacity as a
I
judge.
think the CJ must remember to mute.
Okay, which I do in my capacity as a judge, and for which my remuneration as a judge is part of my remuneration as the chair of the commission. So I think in all fairness, one must look at the value for money proposition in a bigger sense. And in respect of a candidate's commitment, I think, and contribution to the country. If it's to be looked at purely as to 6 years and someone else will serve 8 years, I think that would be firstly somewhat mechanical. And I think it'd be unfair because it wouldn't take into account the candidate's contribution. Whether I serve the judiciary or whether I serve the Human Rights Commission, I serve my country. I think that's ultimately what matters. Thank you.
Thank you, CJ.
Thank you, Honorable Malema. And Judge Kolapen, which Honorable Singh, Honorable Malema?
Thank you very much, Chief Justice. I'm just worried you said we were asking 2 questions, so I had 15 years, so I don't know how I'm going to navigate that one. Does Section 25 provide for expropriation of land without compensation?
Yes.
Can you expand on that?
Yes. In my view, if one applies the criteria other than market value.
Can you speak into the mic?
Certainly. I was trying to look at Commissioner Malema out of respect to him. In my view, yes. If one applies the other criteria other than market value, and the net effect of those is that you end up with a zero value property, then there must be expropriation without compensation. I act, for example, for a community who were restored land on which there is a decommissioned dam that used to belong to a water board, as well as a loss-making nature reserve. The water board were awarded 16 million rand in compensation for the land. The community inherited a loss-making asset, which is causing enormous trouble for them. And I've advised them that they should bring a challenge to the original agreement by which they restored the land, on the basis that there should have been more compensation paid to the water board, and that in fact that 16 million rand or something of that order ought to have been awarded to them as financial compensation to enable to deal with the loss-making asset that they were then handed.
Is there any specific case where you can refer us where the state expropriated land without compensating the owners of the land, and there were no serious legal challenges or consequences to that effect?
The only examples I have are the 2 that I gave, which I advised in relation to the National Forest Act, but I don't know of any other cases, no.
Now, given the fact that you have not acted at the Constitutional Court, and you are a white male with no such experience of acting at the Constitutional Court, what makes it so special for you to be appointed at the Constitutional Court against all other people who have acted at the Constitutional Court, who are black, some are females, and are contributing to, their appointment will be a contribution to the transformation of the judiciary? What makes it so unique? What is it so unique about you that will make us want to overlook the previously disadvantaged people who are qualified like you, who have got everything that it takes, even beyond, because they've got an experience? You come from not being there in the lower courts and building up and acting in the Supreme Court of Appeal and Constitutional Court, acting there. You haven't done that. You just come straight, boo, into the Constitutional Court. What is so unique about you?
I would never profess any uniqueness about myself, and that isn't the basis on which I come here. The basis on which I made myself available in response to a nomination, or 2 nominations, was on the basis of Section 174, Section 5 of the Constitution. That's a provision that says that 4 of the 11 judges must have been serving judges at the time that they were appointed. In my view, the implication of that is that the framers of the Constitution wanted a range of influences. It's exactly the same in respect to Section 174(2) in respect of the race and gender provisions. And I'm not sure if you've read, but there was an article written by Bayete Maswazi, who at the time I think was the Deputy President of the BLA. He wrote an article in the Advocate magazine in response to a speech that was given by Judge Kachalia about transformation and the work of the Judicial Services Commission. And the point that Mr. Maswazi made was that what the Constitution wants is a range of perspectives to influence its adjudication. That's the reason why there's 174(2). It's not simply a game of pigmentation. What the framers of the Constitution want is a range of different experiences so that people come there and give their perspectives and enrich the adjudication. I don't claim to be special, but what I do have is a different path through adjudication. I don't say there's anything particularly special about it, but what I say is that it can be of assistance to the Constitutional Court, and the provision has been used for other judges. Judge Mutlanga, who serves on the court at the moment, followed a similar path. He also wasn't a judge at the time that he was appointed. The same with Justice Yakub, the same with Justice Chaskelson, and I think there are some others too. So my application is humbly brought. I completely respect the Judicial Services Commission's difficult task that they have in applying Section 174(2). They also have to apply with respect to Section 174(5). And that is the basis upon which I have made myself available. But obviously I respect the decision that you come to.
But the point I'm making is that by appointing you, will we be advancing the transformation of the judiciary?
Yes, we will. And I say that for this reason. Transformation is not an issue that relates solely to the demographic representation on the bench. Transformation of the judiciary is also a style of adjudication and what is taken into account by judges when they decide cases. And I would respectfully submit that the particular path that I followed, which has been different from almost every other lawyer, has provided me with insights, has provided me with perspectives that I can helpfully bring to bear. But most importantly, when one looks at the articles which have been written in particular by Justice Lange and by Justice Musneke about transformative constitutionalism and transformative adjudication, transformation goes much wider, and it's the style of adjudication is also part of it. And I believe that my experience can bring with it a style of adjudication that can be of assistance to the court.
Thank you, CJ.
CJ? Thank you very much, Malema.